Senate Judiciary Committee to order. Our committee member, Senator Pyle, I believe, is appearing by WebEx this morning. And we will start then with a request for bill introductions. Do we have any bill introductions for committee this morning? That's correct. I think we have Nancy Strauss from the Kansas Judicial Council who would like to introduce some bills via WebEx. So, Ms. Strauss, if you're in the meeting, please proceed. Ms. Strauss, if you'll enter your name into the WebEx meeting, we can go ahead and hear from you then. Okay, there we go. Go ahead, Ms. Strauss. Thank you. Welcome to committee. We can't hear you. You'll have to unmute your microphone. Thank you.
I am terribly sorry about connection issues. I'm Nancy Strauss. I am appearing on behalf of the Judicial Council, and I would like to request introduction of 6 bills. The first is 21 RS 0540, and it is relating to expungement and unpaid fines and fees. The second is relating to termination of parental rights when a child is conceived by a sexual assault, and it is 21 RS 0371. I have a third one regarding the Uniform Fiduciary Income and Principal Act, 21 RS 0509. The fourth amends the Power of Attorney Act, 21 RS 0506. The fourth is regarding the Uniform Directed Trust Act, 21 RS 0593. And the last one amends the Kansas Uniform Rules of Evidence, 21 RS 0245.
Thank you, Ms. Strauss. Are there any objections to the introduction of the 6 bills? Seeing none, the bills will be so introduced. Are there any other bill introductions? Senator Wilborn.
Thank you, Madam Chair. I have a bill request. It's RS 0052. The bill is requested by Senator Longbine, Chairman of FI&I. He is now in session as we speak. It is on behalf of a secure facility in Junction City. It will allow judges to have discretion of runaway juveniles. And
Thank you, Senator Wilborn. Are there any objections to the introduction of the bill? Seeing none, the bill is so introduced. Thank you. Committee, just a quick housekeeping matter. We've had some background thoughts and about procedures for committee regarding paperless committee. The committee is paperless. We can accept conferee testimony by PDFs, please, 24 hours before a committee meeting. Any committee member who wishes to have paper copies of testimony, please let the committee assistant know, and we will make sure that those documents for committee meetings are in your folders. So that's how we'll proceed then. Next item on the agenda, we will open the hearing on SB 3, and we will start with the bill brief by the reviser. If we have the reviser on the WebEx meeting, please proceed.
All right, and Madam Chair, this is Jenna Moyer in the Office of Reviser Statutes. Jason is having a little difficulty with his connection, and so he's going to have me read the bill brief. I just have to pull it up from my desktop.
All right, thank you. Committee, your Senate bill should be, that we're hearing today, should be in your committee folder.
Here we go. Okay, this is a bill brief for Senate Bill 3, and Senate Bill 3 creates a certified drug abuse treatment program for people on diversion, and it would allow county and district attorneys to enter into agreements with court services or community corrections for.
The WebEx feed isn't functioning properly. We can't hear you because it's being interrupted and it's only spotty that we're hearing you, not because of your microphone being off, but I'm not sure if we could get any more clear connection. We can only hear about every other third word or so.
Oh, and it looks like Jason is just getting on. So maybe if we give it a minute, the feed will correct itself.
All right. Mr. Long, are you able to go ahead and proceed? You'll have to turn your microphone on.
Madam Chair, this is Jason Thompson. Can you guys hear me now?
Yes.
Very good. A lot of connectivity issues between our office and WebEx this morning, so I apologize. All right. So as Jenna was saying at the beginning, Senate Bill 3 creates a certified drug abuse treatment program for people on diversion, and it allows county and district attorneys to enter into agreements with court services or community corrections for supervision. New Section 1 of the bill creates the certified drug abuse treatment program for folks who enter into a diversion agreement on and after July 1st of this year on a complaint alleging a felony violation of KSA 215706, that's possession of drugs, whose offense is classified in grid blocks 5C through 5I, and who have no prior felony drug convictions. So it's a limited set of those offenders that would be eligible for this.
Well, the WebEx feed is having difficulties again. We can again only hear about every third word. Without the bill brief, let me have just a moment and determine how we're going to proceed here. Committee, on your, you should have in your email inbox the bill brief PDF from the reviser. If we can take a few moments, I don't know, doesn't look like every committee member has. Sure. I'll take over. Jason, you want to try again? We see you up on the screen. We can try again, and if it doesn't work, then I'll go over the bill brief quickly for committee. Go ahead.
Yes, sure, Madam Chair. I'm going to stop my video and see if that helps just lessen the load on the connection. Okay, so I'm still here. All right, so if you have the bill brief, it would be great to go ahead and follow along, but I'll try to keep it short. New Section 1 creates this new certified drug abuse treatment program for people who enter into diversion agreements. Only a limited set of those folks convicted of or on diversion for a possession offense with a certain criminal history. The people participating in the program would be supervised by community corrections or court services under agreements entered into with the county or district attorneys. They would be discharged if they are convicted of a new felony or have a pattern of intentional conduct that demonstrates a refusal to comply with or participate in the program, in the opinion of the county or district attorney. And folks that are discharged would be subject to revocation of their diversion agreement. The second section allows the county or district attorney to enter into those memorandums of understanding or memo of understanding with the chief judge of a judicial district or with community corrections to assist with supervising people on diversion. The county or district attorney would, of course, retain authority over whether a defendant is given the option of diversion and whether a diversion agreement should be revoked. There are provisions in there about how the Office of Judicial Administration will have guidelines if there is a memo of understanding between county or district attorney and a chief judge. Section 3 then allows diversion agreements to include provisions about supervision by the county or district attorney or by court services or community corrections under those MOUs, memorandums of understanding that we just discussed, including fees and costs. Section 4 then allows community correctional services to provide those supervision services pursuant to those MOUs. And finally, Section 5 provides for the certified drug abuse treatment programs to be used in the case of diversion as opposed to just conviction. It requires the county or district attorney to determine the extent to which a person can pay for assessment and treatment and use any costs they can pay to offset the supervising agency's costs. So hopefully you caught most of that. If not, I know you've got some conferees that can really explain this well, but I'll see if you have any questions.
Thank you, Jason. Are there any questions for the revisor? And the committee, I'll direct your attention. We do have a fiscal note for SB3 in your committee documents. If you don't have the committee documents in front of you, the last paragraph of the fiscal note indicates that the Kansas Sentencing Commission estimates that additional state general fund expenditures of $88,368,000 or $176,737 or $265,105 in fiscal year 2022, depending on which of 3 scenarios occurs. And there's 3 scenarios that talk about additional prison admissions and beds and the drug treatment offenders program. So you have more information on the fiscal note in your committee documents. I don't see any questions for the revisor. So with that, we will start with proponent oral testimony. We have Scott Schultz from the Kansas Sentencing Commission. Mr. Schultz is appearing by WebEx today. Welcome to committee.
Thank you, Madam Chair. Members of the committee, can you hear me all right?
We can. You're not on video, but we can hear you fine.
Is that any better?
You can go ahead and proceed audio. We still don't have video, but go ahead and proceed. Thank you.
All right. Thank you, Madam Chair. I was wondering whether or not if you can only hear every third word, does that mean I get to talk 3 times as long? Or
well, now, Mr. Schultz, I'm going to interrupt for just a moment. Your audio, okay, there you're on video, and the audio was choppy, so we're going to try again. If you'll go ahead and start over. Thank you.
All right. If you cannot hear me, I will stop my video as well if that seemed to actually help the situation. So please do just let me know. I thank you again on behalf of the Sentencing Commission for being able to present testimony in favor of this bill. I venture to guess that you probably will. This will probably be the least controversial bill that you have today to discuss. But this is brought to you by the Joint Corrections and Juvenile Justice Oversight. These are one of the several bills that were actually pre-filed. The Sentencing Commission, as well as the Kansas Criminal Justice Reform Commission, also join in recommendations for this in support of this bill. As some of you are aware, this particular bill in similar form was passed out of the House 125 to nothing last year. It was 2020 HB 2708. And so just makes fiscal sense in terms of where we are in the process. Many of you are aware, and I kind of like to go a little bit into, for those of you that may not be familiar with diversion and what's commonly known as the Senate Bill 123 program, what those 2 things really are, and then kind of get into the meat of what this particular bill does. Diversion is a program run by the county and district attorneys across the state. There is some structure to it, but all in all, prosecutors have the ability to set up their own diversion programs. There are some that use it extensively throughout the state. There are some that won't even divert a traffic ticket. So it is it's basically just an agreement
Mr.
between the.
Schultz, there we go.
Yes.
You turned off the video so we could hear you a little bit better. It's been choppy audio. If you could turn your video off, that might help. Thank you.
You're welcome. I went ahead and did that. So in a diversion context, it is essentially an agreement between the offender and the prosecutor.
Now we
And
can't hear you at all, Mr. Schultz. I don't know if the microphone got turned off as well.
are you able to hear me now?
We're still not hearing any audio from Mr. Schultz.
Can you hear me now?
Yes.
Okay. So diversion essentially is an agreement between the prosecutor and the offender. And this is a pre-filing sometimes that's done, pre-trial type of mechanism that allows the offender to keep from getting the conviction on their record if they agree to go through terms and conditions set by the prosecutor. And those are normally staying out of trouble and not committing new offenses. And if there are any particulars as far as paying the victim back or something of that nature, that's part of the diversion agreement. One of the major parts of an agreement is they normally have to sign an affidavit that set out facts that essentially will convict them if they don't comply with the diversion agreement. So if they do fail in completing the diversion successfully with the prosecutor's office, all the prosecutor has to do is take that affidavit into court, file the case, and that it's pretty much
Lost the
done.
audio again.
Can you hear now?
So it looks like it's a WebEx problem. WebEx is registering speaking, but we're not able to hear it in the committee meeting room. Well, Mr. Schultz, we'll give you, if you'll speak and maybe we can hear you, and if not, we'll move on to the next conferee. I apologize.
Can you hear me now again?
Yes. Yeah.
Okay. So the diversion agreement then allows several things. And that particular, it allows the prosecutors the ability to still recover restitution from the victims, still be able to provide change as far as the offender is concerned. In exchange, the benefit to that offender is they may not get a misdemeanor or a felony conviction on their record. This particular provision, which, as I indicated before, has received broad consensus in terms of support, would actually provide state-paid substance abuse treatment on the front end in the diversion process. That doesn't happen right now. Many large prosecutors' offices have diversion coordinators. Many of the smaller communities barely have a prosecutor or even an assistant. So, so this would provide a mechanism in which the prosecutors could, they wouldn't be required to, but they would have the opportunity then to enter into agreements with the court as well as community corrections to provide supervision. The Senate Bill 123 program is and as far as this particular bill is concerned, this would be for possession of controlled substances. So if that was the potential divertible offense, that would be what this bill actually would cover. The current Senate Bill 123 program that my office administers throughout since 2003 is a post-conviction program. And the idea here is we have the infrastructure already set up. We have the treatment providers throughout the state that could actually enter into agreements with the local jurisdictions just as they already do. And that infrastructure is already set up. So they could actually, the commission essentially acts as a bank that we pay the treatment providers when we receive those invoices from them. So some of the
Mr.
advantage of
Schultz,
this.
Committee will reserve questions till after we've heard from all the proponents. Next, we have John Jenks from the Greater Kansas City Chamber of Commerce to provide oral testimony on WebEx. Mr. Jenks, welcome to committee.
Thank you, Madam Chair. I'm going to leave my video off preemptively in the hopes that the audio works. So thank you again for allowing me to testify today. I am John Jenks, Director of Public Policy at the KC Chamber, and the KC Chamber urges this committee to favorably pass SB 3. The KC Chamber is supportive of expanding drug treatment programs in the state of Kansas to improve outcomes for people stuck in the endless cycle of addiction. Most of us have a family member or a friend who has been caught up in the vicious trap of addiction and has seen the damaging effects drugs can have on a person's life. It's also pretty unique for a chamber to care about these issues of drug treatment and criminal justice, but the KC Chamber looks at this through an economic and jobs lens. This is why, as some of you may know, we started our Workforce Opportunities for Returning Citizens initiative a couple of years ago. The aim of this initiative is to get justice-involved individuals and returning citizens hired with our members. I'm proud to report that despite COVID delaying some of our progress on this initiative, we've begun to see folks getting hired, and I think have at least 5 folks hired now by chamber members through this initiative. Looking ahead and specifically looking at this legislation, expanding drug treatment programs for Kansans on diversion is a great step the legislature can take to show that it is serious in addressing the drug epidemic gripping Kansas and our country right now. And unfortunately, as we pretty much have all seen and heard anecdotally, this crisis is only going to get worse as the coronavirus pandemic and increased isolation and closures continue. This bill is also a jobs opportunity, as I've kind of touched upon earlier. As you all know, a person who is justice involved has a much better likelihood of success and rehabilitation if he or she is surrounded with family and support and is able to maintain stable employment. And this bill also, Scott also mentioned this bill also allows these offenders to withhold a guilty plea, which can permanently affect their prospects of getting a this bill is an opportunity to keep folks really participating in the workforce, which is going to be a key as the economy continues to recover and baby boomers continue to leave the workforce for retirement. The Chamber applauds the efforts of the Criminal Justice Reform Commission and this committee and looks forward to working with you all and the commission moving forward to improve outcomes for justice-involved individuals. So in all, the Chamber supports this bill, and I'm happy to stand for questions at the appropriate time. Thank you.
Thank you, Mr. Jenks. Next, we have Kendall Seal from the ACLU. Welcome to committee.
Chairwoman Warren, members of the committee, thank you for the opportunity to present testimony. My name is Kendall Seal, and I'm the Director of Advocacy of the ACLU of Kansas. We're a nonpartisan nonprofit org that works to preserve, strengthen constitutional liberties and rights for all Kansans, and we agree with the goal of SB 3, but as it's currently drafted, it maintains a bit of the status quo with regard to the costs associated with the program, and we would offer the following suggestions for this committee's consideration. First, the diversion costs, fines, and fees are a barrier to successful completion. Requiring the payment of fines and fees in order to participate can undermine the program by automatically creating a financial barrier to participation. Additional fees, such as weekly or monthly or analysis fees, pose another barrier to successful completion. These types of fees can be the difference between paying rent and securing transportation to get to work, similar to the concerns raised by the Chamber in terms of economic development. These fees also disproportionately impact people of color, which can reinforce structural racism within the criminal justice system. So we would recommend the elimination of the costs, fines, and fees associated with the diversion program for divertees. Second, this bill is too narrow in scope because it only includes level 5 drug offenses on the drug sentencing grid. People in possession of amounts that would be comparatively low elsewhere could, in Kansas, be categorized far differently and with severe implications. Most importantly, these people should not lose access to treatment. We recommend that until the sentencing grid is updated, eligibility is expanded to provide greater flexibility and avail more Kansans of treatment options. Finally, this bill has no prosecutorial oversight mechanism nor an avenue for robust transparency. At a minimum, we recommend the inclusion of an annual report on diversion programs be shared with this committee. Including this provision will strengthen faith in the criminal justice system, and we support SB 3 affirmatively with these adjustments.
Thank you, Mr. Seal. Are there any other proponent oral conferees in the committee room or on WebEx? Seeing none and hearing none, there is written proponent testimony from Ed Klump, Kansas Association of Chiefs of Police, Kansas Sheriff's Association, and Kansas Police Officers Association. We will now open it up for any questions from the committee members for any of our proponent conferees. Senator Haley.
I apologize, Madam Chair. I just wanted to ask Mr. Seal, I didn't catch your third. I don't know, I just kind of blanked out. Maybe it's been all the WebEx of my mind. But your third, you made your 3 points, the cost first, and of course changing the sentencing grid from a 5. And your third point again, sir?
Certainly, Senator. The third point is there's no prosecutorial oversight mechanism or a robust avenue for transparency with this bill.
Thank you, sir. Thank you, Madam Chair.
Thank you, Senator Haley. Any other questions from committee members? I have a couple. Mr. Seal, are you going to be proposing some amendments, or these are just your policy ideas?
These would just be our policy ideas. We certainly would recommend an amendment to this bill in terms of an annual report mechanism to this committee on the diversion program. We think that will include improve the transparency aspect, eliminating the fines and fees or being a little more directive in terms of the scale of the fines and fees may be in order as well in terms of an amendment here.
Thank you. Senator Haley.
Thank you, Madam Chair. Previous reference to last year's bill, 2708, Mr. Seal, since you're there, were the concerns that you raised a part of that? I know that you're new, but do you know if they were raised during the discussion of what was House Bill 2708 in 2020 session? Some of the areas that you outlined.
And I apologize, Senator. I'm not familiar with that particular bill from the last session, but I can circle back to you on it.
Thank you. I'd like to ask him if some of these areas that were mentioned by Mr. Seal might have been contemplated during that debate, whenever that time is appropriate.
Sure, we can do that now. Mr. Schultz, it looks like you're available by WebEx. If you'll, did you hear Senator Haley's question? If yes, please identify yourself and proceed.
Madam Chair, I did not hear the question. I'm sorry.
Senator Haley, would you repeat that?
Thank you, Madam Chair, and thank you, Mr. Schultz. Mr. Schultz, a conferee has come with the ACLU and raised 3 areas that are of concern to his entity regarding this bill, Senate Bill 3, where it might be in.
I'm sorry if you can hear me. I lost the feed.
Is just in brief, if you recall any discussion of those areas during 2708 last year. And if so, how they may be incorporated if we seek to amend Senate Bill 3.
Senator Haley, can you hear me?
We just heard your question. Can we hear you? Yes, we heard that. Go ahead and
Okay.
speak, and we'll see if we can still hear you.
All right, I apologize. My recollection
Mr.
is
Schultz
that,
again?
yes,
Just
my
identify
recollection.
yourself.
This is Scott Schultz. My recollection is we did not have those three type of suggestions to deal with from the last hearing last year.
Thank you, Madam Chair. Thank you, Mr. Schultz.
Thank you. Any other questions for proponents from the committee? Seeing none, we have an oral neutral conferee, Stuart Little, Kansas Community Corrections Association. Please introduce yourself and welcome to committee.
Thank you, Madam Chair. I appreciate the opportunity to appear before you all for the first time, and any communication issues will be my own, so may make it easier. I'm here today on behalf of the Kansas Community Corrections Association, the statewide organization that's rooted in your county government, funded by the Department of Corrections, who does supervision for folks on higher level probation. So court services does low risk, and medium community corrections does higher risk. We supervise most of the offenders that are on the Senate Bill 123 program. We are supportive of this diversion bill. I am listed as a neutral because I don't like to come in and testify and say we're supportive if you do what we want. So we're neutral, but we have a suggestion in here. The bill has the continuation of the fund that the department, or that the Office of Judicial Administration collects from offenders on supervision. Those funds stay with the Office of Judicial Administration. One of the requirements in this bill is that community corrections will be serving some of these diversion folks. Now, originally when the bill was introduced, there was some assumptions that lots of these folks would be low risk, and so they would be done by court services. Once the bill has come out and it's been shared with various organizations, I'm hearing from some of the community corrections programs that they're in discussions with having community corrections do the supervision, because these are kind of specialized population that you want to try to get to deal with, and including big and small, some of them large, including Sedgwick County. And so what we're interested in having done here is either, there are two solutions, and they're in the second paragraph of my testimony, would be it's so that the supervision funds, which are by the way the bill is written, and I can point you to those covering the cost for this, there's no mechanism for community corrections to receive a portion of those funds. So what we're interested in is either modifying the statute for this correctional fund, wherein you would have a distribution of those collected funds in that judicial district, if it's community corrections that's supervising, because they're different agencies. Or, and this may be the more elegant and simple solution, the section in there on the memorandums of agreement, it says memorandums of agreement will be made. If you could insert language in there that would say, included in those memorandums of agreement would be a proportional distribution of funds between community corrections and court services, so that if a county like Sedgwick, that is likely to have a larger number, or Johnson, or any county for that matter that may do this, that a portion of those funds, which they're designated in there specifically to cover these costs, would be distributed under the terms of the memorandum of agreement. I'd be happy to answer questions.
Thank you, Mr. Little. Are there any other conferees, neutral conferees in the committee hearing room or on WebEx? Seeing none, are there any questions for Mr. Little from the committee members? Seeing none, committee, we also have written neutral testimony from Randall Bowman, Kansas Department of Corrections. And with that, then, we will close the hearing on Senate Bill 3 and open the hearing on Senate Bill 7. Jason, if you could give us the bill brief on Senate Bill 7, that'd be appreciated. Thank you.
Thank you, Madam Chair. This is Jason Thompson with the Revisor of Statutes again. Senate Bill 7 extends terminal medical release to inmates in the custody of the Department of Corrections with a condition likely to cause death within 120 days. The statute that's amended is KSA 22-3729, which currently allows the Prisoner Review Board, upon application by the Secretary of Corrections, to approve an application for terminal medical release if the chair of the board determines the person has been deemed by a doctor to have a terminal medical condition likely to cause death within 30 days and does not represent a future risk to public safety. This terminal medical release is subject to revocation if the person released does not die within the prescribed time period. The bill would authorize this same release procedure if a doctor has determined the prisoner has a terminal medical condition likely to cause death within 120 days, rather than the 30 days prescribed by the current law. I'll see if you have any questions.
Thank you, Jason. Committee members, any questions for the revisor? Yes, Senator Haley.
Thank you, Madam Chair. Not so much for the revisor, Jason Thompson, but for a future answer, if we might, as we deliberate this bill. If our researcher who's on, I see Robert Gallimore, might assist us to know how many other states indeed have compassionate release and what those timeframes are. I'd appreciate that as we augment it, if we could.
Thank you, Senator Haley. Does the revisor's office have that information currently about how many other states have similar statute?
Madam Chair, this is Jason Thompson again. No, we do not have that readily available, but between us and our research staff, I'm sure we can get that for you.
Great, thank you. And I see Natalie Nelson from research. Natalie, is that some information we have currently available?
I don't believe we have it currently, but we can look into it and get it to you.
Great, thank you. Appreciate that. Committee, there is a fiscal note also in your committee documents that you can review. There's no specific monetary numbers provided in the fiscal note, but you can read that. We'll see. We'll proceed then with proponent oral testimony. We have Scott Schultz from the Kansas Sentencing Commission. Scott, welcome again to committee.
Madam Chair, members of the committee, I'm scared to talk right now, but I hope you can hear me.
We can hear you.
Thank you. So this particular bill, again, is brought to you by the...
I can't hear you. Is WebEx detecting that he's speaking?
I'll shut my video off, if that will help, maybe.
Okay, we can hear you again.
Can you hear me now? So this bill is brought to you by the Joint Corrections and Juvenile Justice Oversight Committee. As I indicated on the previous bill, these were pre-filed on both the House side and the Senate side. This is deals with a compassionate release policy that is already in place with KDOC. It is also recommended by the Sentencing Commission, and I am testifying on behalf of the Commission today. The similar bill, 2020 HB 2469, is a similar bill that passed out of the House 125-5 last year. The compassionate release concept is essentially allows prisoners that are facing imminent death to have early release. This is usually due to advancing age, declining health. In this particular situation, it has to be a situation in which the inmate has been certified essentially by a physician that they will die within 30 days. We are requesting that be increased to 120 days. For the following reasons. Normally, elderly prisoners are with medical conditions do not pose a threat to public safety that younger folks would normally pose. It just kind of goes without saying that when they're dealing with those medical issues, cognitive, mental health conditions, terminal illnesses, they are not only more costly to care for, but they're actually the least likely to be arrested and be returned to prison. So again, it's a cost issue, but it's also a little bit of humanity in the situation that can be actually applied, and those individuals would be released early. Part of the problem with the current law is that, and I've included in my testimony, and an answer to the question as far as the survey, if you look at footnote 8 of my testimony, there was a survey that was actually done, and that actually went through many of the states and set out what their policies are, who it applies to, and for how long. There are a handful of states that provide for early release of terminally ill prisoners that require a prognosis of only 30 to 60 days. Unfortunately, Kansas is one of the most extreme examples, and that was actually noted in the study that we lag behind as far as eligibility. And the practical fact of the situation is 30 days is not long enough.
Lost the audio. We cannot hear you, Mr. Schultz. We can see you. Why don't you try speaking and see if we can hear you?
Can you hear me now?
Yes.
Okay. With the practical effect is 30 days is not long enough for an individual to be eligible, because that individual, if it's 30 days before death, they'll die before the paperwork is actually completed by DOC. DOC currently is estimating with this new change of 120 days to death that they would get 9 to 10 inmates per year that would be eligible. That doesn't mean that they would actually be approved for release, but they would be eligible. Whereas in the previous fiscal years of 2016 through 2020, only 0 or 1 applications were actually received per year. So granted, this is not a huge impact on the system, but at the same time, it allows for the Prisoner Review Board, who actually reviews all these requests, to have more flexibility, and for it to actually be a reality of that folks would actually be released. Now, keep in mind that that the Prisoner Review Board is not, just because it's 120 days out and they
Sorry,
apply.
we lost the audio again.
Can you hear me now again?
Here we go. We can hear you.
Okay. Just because they're 120 days out from death doesn't mean that the Prisoner Review Board is going to approve that. There are multiple criteria that are in place, such as age, criminal history, length of sentence, time served, and the nature of offense and the risk or threat to the community. So there are, again, backstops that are already in place in statute that wouldn't be new, that would actually ensure. And in fact, if the individual lives even longer than that, there are still statutory mechanisms to actually bring that individual back into prison. So essentially, the only thing that's changing in this bill is we're changing the time period from 30 to 120 days. So we believe that the cost associated with this versus the public safety threat is something that is the cost itself outweighs the potential public safety threat. And with that, I'll stand for questions.
Thank you, Mr. Schultz, and committee will have questions for the proponent conferees after the conclusion of all proponent conferee testimony. Next, we have Kendall Seal from the ACLU. Welcome again to committee, Mr. Seal.
Thank you, Chairwoman. First, this bill is sound policy because it affirms that terminally ill people no longer pose a public safety risk. Currently, residents may be released within 30 days of their anticipated death. Releasing people within 120 days of death is humane, as those individuals are clearly very sick. The state's interest in incapacitation from a public safety standpoint is no longer applicable. By supporting this act, you'll expand the time frame to 120 days, which is commendable and humane. Second, this bill could impact the aging population of our prisons. While age is not necessarily a proxy for health status, it is important to be mindful of the demographic trends. As of June 2020, an estimated 19% of the Kansas prison population is age 50 or older. The overall cost reduction, as previously noted, will be limited in the near term, but this represents a step in the right direction. As a broader issue, we urge the state to adopt clear, common sense, and objective criteria for elderly or serious medical condition release. Some states' criteria consider age and years served. For example, in Virginia, residents are eligible if they're at least 60 years old with 10 years served, or 65 years old with 5 years served. Incarcerating elderly and medically vulnerable residents does not serve a rehabilitative purpose, as the necessary services to assist them in a prison setting are not available. The goal of deterrence is not served by continued incarceration because these prisoners already pose low public safety risks. Reentry programs, reintegration, and treatment offer an alternative to incarceration. I should also note that some states use criteria such as like Wyoming. Their treatment there, if the level of care in the prison setting cannot be provided, that provides an opportunity for release. The high healthcare, housing, and security costs of the state could be reduced. To give you a sense of those costs, KDOC in their fiscal year 2020 report, Kansas can save between $3,717.29, this is the marginal cost, to $30,100, this is the average cost per year per aging prisoner released. Releasing aging and seriously ill prisoners who pose little safety threat can save taxpayers millions of dollars and merits additional engagement by this committee. Thank you.
Thank you, Mr. Seal. Committee, we also have written proponent testimony from Randall Bowman, Kansas Department of Corrections. Do we have any questions for any of our proponent conferees? Before we get to questions, let me call for any other proponent conferees that we have in the committee meeting room or on WebEx. Seeing no other proponent conferees, we'll open it up for committee member questions with Senator Thompson.
Thank you, Madam Chairman. This is for Scott Schultz. You mentioned that the paperwork takes longer than 30 days to process. How long does it actually take to process paperwork for this type of thing?
Senator, that's a great question. I don't have the particulars for you, and that would be something that I don't. If Randy's on, he may be able to jump in there. But it is a process in which my understanding is that DOC actually does that application on behalf of the inmate, and then it obviously has to go through the channels. And so I would love to take that question, but I think I could, since Randy is here, I might just try and defer to him.
Thank you, Scott. Thank you, Senator, for the question. I hope my audio is working since it's the first try.
Please introduce yourself for the committee and those listening online.
Yes, Chair, thank you. So my name is Randy Bowman. I'm the Executive Director of Public Affairs for the Kansas Department of Corrections. Yeah, that's one of our primary interests in this bill is seeing that time frame change. It quite literally, because we take a process for if we make an application to Prisoner Review Board, then the process includes communication with prosecutor that was involved or prosecutors, the court, victims, family, all that takes time. And then some of the most significant challenges, as you might guess, because of the phrase they're terminally ill, is a viable release plan. So finding housing for these folks, really they have to go to a hospital if there's no family available or some type of clinical setting. Those are preciously few commodities out there for this population. So the 120 we think will get us those bigger numbers, but 30 days gets us We just had one of these last summer for the first time since like 2013. 30 days just doesn't let it happen today.
Thank you, Madam Chair. Thank you.
Yes, sir.
Other questions from the committee? Yes, Senator Gossage.
My question, thank you, Madam Chair. My question is, you mentioned these people would go to a hospital or some other place for care. Do we know where these other places are? I mean, what have been some of the experiences of these folks when taken out of prison and put into other places? Who pays for that? And what has been the experience?
The
Please
one,
identify yourself.
Randy Bowman
Go ahead,
again. Randy Bowman again, Kansas Department of Corrections. So the one that was out last year actually worked out because family were able to take him in, but that is just not a common occurrence. So theoretically, the other would be a nursing home, would probably be the most common. We're talking about folks who, cancer is probably a common medical need. So the medical needs being paid for by the taxpayer when they're in the facility, but how to get them medical care when they're out in the community is iffy at best.
May I, Madam Chair, one more follow-up? So in reading the opponent testimony to this, it was brought up that, well, the families of that were victims, or the victim themselves or the families of victims, have any say about these people who are leaving, or is that not taken into consideration at all?
Randy Bowman again, Kansas Department of Corrections. Yes, the Prisoner Review Board within DOC consults with our Victim Services Department, who will work with the victims.
Thank you.
Any other questions from committee? I have a question for Mr. Bowman to follow up on the senator's question about who pays for the nursing home and who pays for the medical care if it's in a facility outside of a facility run by the Department of Corrections. Does the bill provide for that?
Randy Bowman, Department of Corrections. I don't read the bill as having any provision to provide a payer source for these persons.
And to your knowledge, then, is there a person who would be released under this bill should it become law? Would other residents of the nursing home information about the person coming into the facility living there with them? Is there any notice provided, or that would be for any of the proponents to answer?
This is Randy Bowman, Department of Corrections. I am not able to think of, at least on the spot, any notification law that exists, but some number of these folks would, of course, be subject to Registration Act for violent offenders, sex offenders, and they'd be a little more typical, your older population. So I couldn't suggest there be a guarantee that facility would know the background, but I think it's probable.
And one final question. We heard from, I believe, Mr. Seal, that some of the other states have requirements of a certain age or a certain amount of time of your sentence already served to be eligible for this program. And currently, Kansas has this program. The bill seeks to extend the time from 30 days to 120 days. So in practice, have younger people eligible for this program, do they use this? Because it could be just not eligible, not just elderly folks, but the younger folks too. And what does that look like if you have any information? It looks like Mr. Seal. Thank you.
Yeah.
Thank you, Chairwoman Warren. Kendall Seal, ACLU of Kansas. So not to conflate categories, and maybe my testimony may have done that slightly, but terminal release here, where we know that death would occur or anticipated death would occur within 30 or 120 days as this bill contemplates, versus something like functional incapacitation. And so the age plus time served kind of categories seek to respond to that kind of functional incapacitation aspect of the conversation. And so that's where it can get to a younger age or age trigger for that. Another option, as Wyoming does, has to do with the relative cost of care in a prison setting versus care outside of the prison setting. And so some states look at that factor.
And under this bill, younger prisoners would be eligible for this as well, right? If they have a terminal condition that would be duly approved?
Yes, Chair.
Thank you. Any other questions from the committee? Senator Thompson.
Thank you, Madam Chair. I'm not sure who to direct this one to, but with regard to terminal illness, I've known some people live well beyond the time frame that they were given, that they were expected to die. You know, part of the reason for incarceration is punitive. And so, you know, my concern is that, and I realize we're talking about a very small population here, but that's a concern. You know, somebody may outlast and be out of prison for quite some time while expected to die. You know, how do we define what is, you know, a death sentence from a health standpoint? I don't know who would want to answer that one.
Madam Chair, Scott Schultz.
Referee available? I'm sorry.
Madam Chair, Scott Schultz. The statute contemplates a definition of what that terminal illness actually means. It also provides for the ability for individuals to actually be brought back into the system if, as I indicated before, they outlive that 120 days, for example. I want to make clear that this section doesn't apply, and that's indicated in the statute itself in subsection D. It doesn't apply to any person sentenced to imprisonment for folks that are in off-grid offenses. So this is so what that basically means is murders, child sex crimes, those type of things would not be actually eligible for release.
Thank you. Thank you, Madam Chair.
Thank you. And I appreciate the answer. That helps clear up kind of my previous question about, you know, other residents in nursing homes where prisoners might be released to, that it's not persons subject to kind of registry requirements. Do we have any other, Senator Baumgartner?
Madam Chair, could someone clarify? I don't think we really have heard yet, but who does continue to pay for the medical coverage and the medical treatment if this were to be enacted?
Do we have a conferee who can answer that?
Yeah, Randy Bowman, Kansas Department of Corrections. I'll try to help with that, and then I might piggyback on the prior one if that's permissible, Madam Chair. But to Senator Baumgartner's question, like any other releasee, they would no longer receive their medical care financed by the Kansas Department of Corrections. We do have staff here who would help them to apply for public assistance, Medicaid, Medicare, if they were of that age group, but not a guarantee that there's eligibility for those. Piggybacking on the second thing, if it's helpful for the committee to know as well, in this process, it requires a licensed physician or doctor in the state of Kansas to certify they're going to pass in this 30-day or 120-day period. So that's not a judgment call by the secretary or the prisoner review board. That is a medical decision that triggers that.
Go ahead, Senator.
Thank you, Madam Chair. As a follow-up, so would that be a licensed physician working for the Department of Corrections, or is that where the family or the incarcerated individual would have to secure a medical individual to come and make that determination?
Randy Bowman, Department of Corrections. So that is our contract medical folks who do that.
Madam Chair, just as a follow-up, I guess my concern in what we've heard so far, I understand the issue of compassion, but I believe that cuts both ways. And family members of victims have been through the judicial process, and a ruling has been made as far as meting out punishment. By the information that's been shared with us within the last few years, there really is not anyone that even fits into this circumstance. So I appreciate that we had this hearing. I believe we had this hearing last year as well. I would urge the committee to move forward on pieces of legislation that are of significant import to Kansans. Thank you, Madam Chair.
Any other questions or comments from the committee? Senator Gossage.
Thank you, Madam Chair. I'm not sure to whom to direct this, but when reading the bill, it was mentioned that people who had committed murder or high-level crimes of that nature would not be eligible, but the bill says any person. So is that specified in here anywhere?
Is that maybe a question for the revisor who can answer that? And then Conferee.
Yes, Madam Chair, this is Jason Thompson with the Revisor's Office. And Mr. Schultz has shared his screen to highlight the provision that I was going to point out to you that's there at the end of the section in subsection D. Does not apply to any person sentenced to imprisonment for an off-grid offense.
Up a bit, but we do see there's a reference, committee, to line 40 on page 2 of the bill. Jason, could you identify for the committee maybe what an off-grid offense is? And we're not
Thank you,
able
Madam
to
Chair.
hear you if you're...
Yeah, I understand that it's breaking up quite a bit. Off-grid offenses are those felonies that receive a sentence not severity level 1 through 10. Common examples would be first-degree murder, child sex crimes with victims under 14, the Jessica's Law cases, as they're known. Those are just some examples. There are 12, 14, something like that, off-grid offenses, if I remember right.
Thank you. And would any conferee be available to answer the senator's question? Or have an answer to?
Madam Chair, this is Scott Schultz again. Jason is correct in his assessment as far as off-grid offenses are normally the most serious offenses that we have. And so the on-grid offenses would be would carry lesser sentences. Off-grid offenses are life sentences. It's mandatory minimum 25 years, and then it goes up from there depending on what particulars have happened. So so those are the worst of the worst. Those are the offenders that receive life sentences.
Who was speaking? Who was speaking, please?
I'm sorry, Madam Chair. Scott Schultz with the Sentencing Commission. I've shared my screen as well, and this is, again, some of the questions that were asked as far as considerations that the Prisoner Review Board would be taking into consideration. And this gives you an idea, again, of the factors that the Prisoner Review Board has to take into consideration. One of those is, again, the risk or threat to the community and whether there's an appropriate release plan that's been established. So there are those factors that are being taken into consideration by the PRB.
Thank you. Committee, if there are no further questions, I would direct the committee's attention to written opponent testimony from Greg Smith, Johnson County Sheriff's Office, and Missy Smith, mother of murder victim. With that, we will go ahead and close the hearing on Senate Bill 7 and open the hearing on Senate Bill 8. If we could have a brief bill brief from Jason of the Revisor's Office.
Thank you, Madam Chair. I keep trying to speak slowly, hoping that it doesn't break up, but stop me if it does. Senate Bill 8 increases good time and program credits for certain offenders in the custody of the Secretary of Corrections. Current law provides good time allowances that reduce a person's prison sentence by 15% or 20%, depending on the type of crime the person committed. The bill would amend the statute, KSA 216821, to provide on and after July 1st of this year, an offender can earn good time of 25% of the prison part of their sentence for a person felony, or they could earn 40% for a non-person felony. Further, the amount of time that you could earn and retain for successful completion of programs and reduce from your sentence would increase from 120 days to 150 days. Finally, the bill retains some current law liability protection for the state, and particularly the Secretary of Corrections, for damages that might be caused by any negligent act or omission in making good time and program credit calculations, but it does eliminate a provision that gives liability protection for a wrongful act or omission. And I will stand for questions.
Thank you, Jason. Any questions from the committee for the revisor? Seeing none, in the interest of time, we have about 15 to 20 minutes left of our committee meeting, so I would ask the 5 proponents who are here to offer oral testimony. We'll have 2 minutes per conferee. First we have up, I'll ask Mr. Vice Chair to keep track of the timer. We'll give you a 30-second heads up about your 2 minutes ending, and we'll ask Scott Schultz, Kansas Sentencing Commission.
Madam Chair, members of the committee, this is a bill that is again brought to you by the Joint Corrections and Juvenile Justice Oversight. It is supported by the Sentencing Commission, and it actually is a similar bill was introduced last year, 2020 HB 2484. House Corrections actually passed it out favorably last year. This is, again, I preface this with violent off-grid sentences do not currently and would not be receiving good time credit. Normally an offender, when they are sentenced, if they're on grid, and I will go ahead and share this quickly. This is the non-drug grid and the drug grids. I've circled in green. They normally, depending on the severity level, receive either 15 or 20% good time credit. This is what we're looking at here is it's a bill to incentivize offenders to do better. And in such a way, we've structured it so that person and non-person felonies receive 25% for person felonies, potential good time, 40% for non-person crimes. This is a situation in which that doesn't mean that they're going to get it just because that it's available to them. They actually have to perform in work assignments, in program assignments. They have to maintain their group living environments. They have to participate in planning activities, as well as have a good disciplinary record. So they actually have the ability to lose good time credit. They also have the ability to earn it back. And so what we're looking for in this is mainly compliance for offenders. Plus it also, again, incentivizes them to...
Mr. Schultz, could I have you wrap up your testimony? I apologize.
Sure. To do better. It also provides for officer safety because fewer inmates in the correctional facilities reduces the likelihood for violence. On the program credit side, we're providing 120 to 150 day. That would be an increase of 30 days. It again would incentivize offenders to complete programming to enhance the likelihood of their success. This is a major bed space impact of 85 this next year that our office has estimated up to 564 for the 10-year period. It is not retroactive to protect those deals and sentences that have already occurred, so it would be prospective. The only thing that I have is some concerns. We had this hearing yesterday in House Corrections. Some of the concerns that were raised were that people would be spending too little time in prison. Our response to that is that if they're being compliant, isn't that exactly what we're wanting to do? and that they have post-release supervision after they get out of prison anyway of 12, 24, and 36 months to still be under supervision by the parole office. And they're subject to
Thank you, Mr.
revocation
Schultz.
setback.
We've got other conferees we need
I
to hear
appreciate
from,
that.
but I appreciate you'll be available for questions.
Yes,
In the
ma'am.
interest of time, and we have, I believe, we might have in-person conferee Dr. Lori Trout. She's on
Yes.
WebEx as well. We'll go ahead and have Mr. Randy Bowman, then Kansas Department of Corrections. And again, if you could limit your testimony to 2 minutes, we'll be helping you with that so we can make sure everyone gets heard. Thank you.
Thank you, Madam Chair. Randy Bowman, Kansas Department of Corrections. I'll just try to pick up a little bit where Scott was, because we're members of the Sentencing Commission too and support this measure and have been at the table for its development. So I'll just expand very briefly on it, that incentive for these residents. 15 and 25% is something. 25% and 40% is a greater incentive. So the consequences for a resident not behaving the way we need them to for the safety of other residents and for the safety of our staff in the facilities, but also in the communities. This lets folks demonstrate that they can behave the way we want them to when they come out to be our neighbors, our coworkers, go to church with us, etc. So it really becomes kind of a policy discussion, or really a policy discussion of how much does the Kansas legislature want to invest in continuing to contain the folks that are demonstrating the desirable behaviors, and would you be willing to let them out sooner, which then leaves limited prison beds for those who are, for whatever reasons, we're unable to reach them and get them to change their behavior, or they're simply unwilling to modify their behavior. So it's a capacity management tool. It's an impactful one compared to all the other little pieces of legislation we've seen this year and last year. This is the most impactful, and it helps manage and prioritize resources to those who are the greatest risk to public safety for inside the facility and in the communities one day when they return, by letting those who are demonstrating better behavior exit sooner. And I'll stand for questions when the time's appropriate.
Thank you, Mr. Bowman. Next, we have John Jenks from the Greater Kansas City Chamber of Commerce. Go ahead in 2 minutes. Thank you. Welcome back.
Thank you, Madam Chair. Thank you, Madam Chair, and members of the committee. The KC Chamber urges this committee to favorably pass SB 8. Just like the other conferees have said, and like I said in my last testimony, we look at this as a jobs and economic issue, and getting more folks back into the workforce. Looking at this legislation, the Chamber supports policies, excuse me, that expand opportunities for incarcerated individuals to receive meaningful educational and reentry programming, and receiving credit for these programs that they are participating in with successful completion. By completing these programs, as the other conferees have said, they are demonstrating that they are seeking rehabilitation and are earnestly taking steps to make himself or herself employable upon release. While increasing good time and program credits for offenders is good policy, we'd just ask that it's important to remain mindful of the need for expanding program capacities inside our facilities to ensure successful rehabilitation for those residents. It's and just like Randy said, it's also a smart investment for the legislature to take for the inmates in increasing successful rehabilitation to reduce recidivism rate and to make these folks more employable upon release and tax-paying citizens. So in all, the Chamber supports SB 8, and I'm happy to stand for questions at the appropriate time. Thank you.
Thank you, Mr. Jenks. Next, we have Kendall Seal, ACLU. Welcome back to committee.
Thank you, Chairwoman Warren. I'll be brief. Kendall Seal, ACLU of Kansas, 4 points. This bill starts to address the capacity issue. Since 1980, Kansas prison populations quadrupled. Over 10,000 people were in prison in Kansas in 2019, a 12% increase since 2000. Other states are downsizing their prison systems. Kansas is expanding theirs by nearly 20% between 2000 and 2017. So there's a rapid growth situation going on in the Kansas corrections space. Second, this bill begins to respond to systemic racism in the state's criminal justice system. This has been accelerated in conjunction with the mass acceleration of incarceration. According to our data, Black Kansans constitute about 30% of the Kansas prison population, but they account for only 6% of the state's population. Third, this bill could blunt the striking rate that Kansas is incarcerating women. Over the past decade, the number of incarcerated Kansas women grew at 3 times the rate of men. 2017, more than half of the incarcerated women were convicted of an offense not involving violence. 38% of those were convicted of a drug offense. Finally, this bill benefits all stakeholders, which is why 32 other states at least have enacted some form of earned time credits. The availability of good time credits based on the merits of a person's actions can make the prison environment safer for other inmates and correctional officers. Additionally, good time credits are an effective management tool. Thank you.
Thank you, Mr. Seal. Next, we have Dr. Lori Trout, offender, who I believe is appearing by WebEx.
Yes. Hello, Madam Chair and Senate Committee. Can you hear me?
Yes, we can. Go ahead.
Oh, great.
Welcome to committee.
Thank you. I really would like to thank you for allowing me to speak with you today. Again, my name is Dr. Lori Trout, and I'm the Executive Director and founder of GROW, Grace Restores Overcoming Women. We provide transitional housing for women that are released from incarceration. I work with the TCF facility there in Topeka. I work with the Adult Residential Center in Gardner, Kansas, and also with the Department of Corrections Intensive Supervision Program. I am very appreciative of the SB 8 and the HB 2031, where you're increasing good time and program credit for those that have been released from incarceration. But I am asking that you would make a modification and extend this also to those that have already been released. And the reason why I'm asking that, there are women in our program, and let me back up, the population I'm speaking of is sex offenders. These individuals have served their time and have gotten out and gone into the community, but they are still having to bear the stigma of being a sex offender. There's misconceptions of sex offenders being all lumped into one basket as pedophilers, perpetrators, molesters, and it's not fair. My history is at 52, I found myself on the opposite side of the law. I ended up in a relationship with my 16-year-old foster son, and I ended up serving 30 days shock time in jail. I had a 3-year probation. I attempted suicide once I figured out and came to my senses of what had happened. And so now I have to register as a 25-year sex offender. The program GROW houses women that, of course, are all felons. And we have a lady that just came from TCF. She served 10 years for one offense. She has a 16-year-old son that she has not seen since he was 6 years old. We have a lady that also came from TCF that served 5 years. And she has to register as a lifetime offender. Now, please don't hear me wrong that I'm saying it's okay to do these crimes, but for one offense, lifetime is pretty harsh. I am asking that, we talk about second chance programs and reentry programs in Kansas, but is it really a second chance when these individuals have to still walk around and carry that load or that burden of being a sex offender or committing that one-time crime? These are individuals that are low risk, no risk offenders. These girls in my program, and I know there are others, they are in the community working, being involved in different programs. They are trying to be productive citizens, but with that label. And so I'm asking that as you're increasing good time for those that are incarcerated, that also be favored to these that have already been released, apply that to their registry time, reducing that time, and or transition them to a diversion program. They will still have the contact with their community supports. They would have a better chance at better jobs.
Dr. Trout, I'll ask you to wrap up in the interest of time. Thank you.
Yes, ma'am. They would have communication, reunification with their families, and opportunity for better housing. So I just ask you to reconsider or to consider modifying that and allow this opportunity for the registry of those that are low offenders be reduced. And I thank you for this time, and I am open for any questions.
Thank you, Dr. Trout. Committee, we have about 10 minutes before the committee meeting is scheduled to be over, and if we'll get to the questions we can today that we have, and if we don't get to all of them, we'll leave the hearing open. Senator Bowers.
Thank you, Madam Chair. Just a quick question for one of the proponents. Are these percentages in line with other states or maybe research or revisers? Do we have our percentages right in this bill? That would be my question. Thank you, Madam Chair.
We have a reviser or a researcher or a conferee who can answer the question.
Madam Chair, this is Jenna in the revisor's office. And I remember in House Corrections last year, we actually got a table that compared the good time credits from other states. And I can look and see if we can find that and distribute it to the committee, because I don't think I have it on hand.
Other questions from the committee? All right, I don't see any. So with that, then, committee, there is no, do we have any other proponent oral conferees, either in the committee room or on WebEx? Seeing none, committee, I'll direct you to committee documents. We have no opponent oral conferees or oral written opponent conferees. Do we have any in the committee meeting room or on WebEx? Seeing and hearing none, we have no neutral oral or written conferees. Do we have any in the committee meeting room or on WebEx? Seeing and hearing none, then we will close the hearing on Senate Bill 8. And committee, then we will meet Wednesday and be hearing 3 additional bills that are on your agenda, and with possible action on bills previously heard. So with that, the meeting is adjourned. Thank you all.